in the San Francisco Bay Area, when someone is arrested for a DUI, the police officers put down what they think the charges should be, and then the paperwork goes to the district attorney's office in whichever Bay Area county that you were arrested in, and they decide what charges are going to go into what's called a complaint. The cops never put down wet reckless as a charge. It's very rare, and the DA's office is just as rare, if not rarer, when they do it as well. A wet reckless is something that often gets negotiated to get the charges lowered. Some would say a wet reckless is a great offer. Some would say it doesn't help at all. My take on it, it depends on the case, the situation. You know, a wet reckless can be incredible if you have an immigration issue. It can keep you in this country. There are many different reasons why a wet reckless is better than a regular DUI. I mean, to start with, the probation is only 1 year instead of 3 years, which to many is a big deal. Fines are less. DUI school in some cases can be less. And for future job purposes and things like that, it can be a very big deal. Now, the original question was, why am I not charged with a wet reckless if my alcohol level was like right at an 08 or under an 08? And the reason for that is that in DUI law, typically when you're arrested for a DUI, it's either for alcohol or for drugs. And if it's alcohol, then they're going to get you for the 0.08. If you're at or over a 0.08, they're going to charge that. And also they're going to charge you with the impairment charge. Now, these are two different vehicle code sections. The penalty is the same. The impairment charge is vehicle code section 23152A, and the per se, the 0.08 or higher charge is vehicle code section 23152B. If it's just drugs, the letter after would be F. If it's a combined influence of drugs and alcohol, they would put a G. Now, a DUI for a low alcohol level, a charge by an arrest by the cops or a charge by the DA's office can also be because of drugs. And that is something that you could be below a 0.08 or have no alcohol in your system at all and be charged with the DUI drugs. Now, how that case ends up, whether we can get it dismissed or reduced or whether we go to a jury trial, is to be determined. But in the beginning, typically, if the DA thinks that you were impaired because of either prescription or non-prescription drugs, or combined of one of those two with alcohol, they will typically charge a regular DUI and not a wet reckless. Again, as I started saying at the beginning here, a wet reckless is something that you are rarely arrested for and rarely charged with. It's something which later is negotiated to or negotiated down to. So that should hopefully answer your question.